In removal proceedings, I got you covered. In today's video, we are going to talk about some of those removal defenses. My name is Bijoux Ngwanda, as you know it. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we're dealing with complex U.S. immigration law cases. If you're new to my channel, just please go ahead and do it. Please go ahead and subscribe. If not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. I'm going to be moving around because I have to show you the screen. In removal, right? The first thing you have to do when somebody's in removal proceedings, the first thing, number one, is take your file, get your file for FOIA, okay? By using the form G639, you file for FOIA, you get your complete immigration file. That's what you write in the application, right? Complete immigration file. And not to mention, you can give some other information in it, the people that can be in the application, spouse, children, etc., etc. Once you get your file, then you prepare. Most of the time, people get referred to immigration court because the asylum application got denied. Not denied, but anyway, USCIS referred them because they couldn't find a conclusion, right? Maybe applied late, maybe not sufficient evidence. Some of them get referred to removal because the green card based on marriage didn't work out, or maybe based on employment did not work out, or maybe they just overstayed the visa. Find yourself in removal. What are those type of defenses you should use? Most people just go with their asylum cases, okay? When their asylum was previously filed with USCIS, you go with it. Some have cancellation of removal as a defense because they've been here for more than 10 years prior to receiving the notice to appear. They have qualifying relatives who will suffer extreme and unusual hardship due to the removal. No criminal offenses, or if they have one, then the criminal offenses is going to be waived if it can be waived. Some other people will try to adjust status, okay? It simply means that this person here, right, the person who's trying to adjust status here is adjusting after receiving the notice of intent, notice to appear in court, right? The first thing they do, they file the form I-130 with USCIS. But they have the highest burden of proof, right? Because now that they're here already in removal proceedings and they're getting married after the fact, then the presumption of fraud is already there, right? Presumption of fraud. Presumption of fraud. So now the standard is very high. The burden is here on the respondent, the applicant, to prove that the marriage in question is a good faith marriage. How do you prove it? Enough evidence, sufficient evidence, affidavit of support, anything that has to do with showing that it is good faith marriage. Sometimes the person does not have all of those defenses. Okay? Now, what are they going to try to do? Try to dismiss the case or try administrative closure if they have younger children, younger U.S. citizen children. At least they'll keep a work permit under the underlying petition that was here. Then once the child turned 21, the child can petition for them. They go back to court, recalendar the case, and try to adjust status. Now the question becomes, when I am in removal proceedings, can I travel outside of the United States? Well, you can try, right? You can try to ask advance parole, okay? You try to ask advance parole using the form I-31, but disclaimer, advance parole using the form I-31 is not a guarantee to come back. It's not. So when you travel under your own risk. I don't really advise when somebody's in removal to try to travel, but sometimes it's really necessary for the person to go out. They can go out and try to mitigate some of those events that's going to lead to denying them entry. For example, having affidavit of support, having all the documents showing the reason why you had to go outside. In case of questioning at the port of entry, right? You can show that and hope for the best. So this is it. This is a short video for when somebody is in removal proceedings and the things they can do. Sorry, I'm trying to erase this. But anyway, if you need a consultation, again, 202-751-2180, email bijoux@esq@gmail.com. Consultation link in the description box below. Consultation fees apply. Until next time, bye-bye.